Hi, this is Jennifer Jaff, Executive Director of Advocacy for Patients with Chronic Illness, and you're watching Know Your Rights. All right, so on this issue of Know Your Rights, we're going to talk about your rights with regard to schools. Now, that means I'm talking to parents because most of the time we're talking about children who have chronic illnesses, who have problems in school. It can be that they have an attendance problem because they're sick. It can be that they're missing school and they need some tutoring, they need some extra help, they need to make arrangements to get their homework when they're out of school, they need somebody to take notes for them in class, any of those kinds of things. And they call us usually because the school is telling them that there's nothing they can do. Well, that's wrong. There's definitely something that you can do. Section 504 of the Rehabilitation Act of 1973 says that if you are a person with a disability, you are entitled to reasonable accommodations at school. Now, that actually applies from elementary school all the way up through college and even graduate school, although the older you get, the fewer accommodations you're likely to get. But the first thing that you need to understand is who is considered eligible for a Section 504 plan. And that begins with the definition of disability. Of course, to make things complicated, to keep us lawyers in business, the law defines disability differently in every different context. So if it's disability insurance or Social Security disability or schools or housing, the definition of disability is going to be different in every single case. For schools, the definition of disability is this: you have to have a substantial impairment in a major life activity. Substantial impairment in a major life activity. So, first question, what's a major life activity? It's anything that most people are able to do without any problem. Walking, talking, seeing, hearing, running, but also it includes bodily functions like bowel and digestion and the immune system. So, for example, if you have a digestive disease and you have a substantial impairment in the major life activities of bowel and digestive function, then you are considered disabled for purposes of Section 504. If you have an immune deficiency, whether because you have a medical condition or as a result of medication that you're taking for something that suppresses your immune system, like a chemotherapy drug, then you have a substantial impairment in a major life activity of immune function, and therefore you have a disability for purposes of Section 504. Now, it's not really quite that simple because in addition to having an impairment of a major life activity, the impairment has to be substantial. And that means you can't just have an illness that really doesn't interfere with the way you do anything. So you can't just have a stomach ache once in a while, but you're able to make it to school and you're able to eat and you're able to basically engage in all of the normal activities of daily life. You have to have a substantial impairment. So it has to be something that really interferes with your ability to function. So if you have a chronic illness, there are going to be times when you have a substantial impairment and times when it's not so substantial. Your disease goes into remission, you have a kind of a theoretical impairment, but it's not really a substantial impairment because at the moment it's not affecting your ability to function. Well, the law was actually amended a couple of years ago to say the following: if you have a chronic illness that would be disabling when it's active, it's considered disabling even when it's in remission, right? So for me with my Crohn's disease, it's considered disabling when it's active because it substantially impairs the major life activities of bowel and digestive function. And so because it is a disability when it's active, it's also considered a disability when it's in remission for purposes of Section 504. So, if you have a disease that at any point will become a substantial impairment in a major life activity, you are disabled for purposes of Section 504, and you are entitled to reasonable accommodations. That's basically the way the law decides who's eligible for a plan of accommodation. If a child has a disability, if a child meets those eligibility criteria, substantial impairment of a major life activity, then the child is entitled to a Section 504 plan. Now, a lot of the times schools will say, well, but the child's doing just fine, getting straight A's, even though he misses some school, doesn't really need a Section 504 plan. Well, that's not how the law works. It has nothing to do with how well you're doing in school. It has to do with your ability to perform major life activities. So you can be getting straight A's and still have a substantial impairment in a major life activity. A child in that situation is still entitled to a Section 504 plan. I'm for Jaff, and you're watching Know Your Rights, and this is our Know Your Rights handbook. If you want to learn your rights to be your own advocate, you can get a copy of this book. This will teach you all about health and disability insurance, Social Security disability, employment discrimination, family and medical leave, educational equity, housing for people with disabilities, and lots of other interesting issues. We've got sample insurance appeals and sample Social Security applications, and lots and lots of information so that you will have all the tools you need to be your own best advocate. Thank you for watching Know Your Rights. This has been Jennifer Jaff. If you have any questions or problems, feel free to give me a call, 860-674-1370, or you can email me at patient_advocate@sbcglobal.net, or you can visit our website, which has lots of helpful information on it, and that is www.advocacyforpatients.org. Thanks very much. Bye.